My name is Marcus Harris. I'm a Chicago-based software and intellectual property attorney. My office has developed one of the nation's leading practices devoted to drafting, negotiating, and litigating software-related agreements with vendors like Oracle, Microsoft, and SAP. And one of the questions that comes up in our practice on a regular basis is it better to arbitrate software contract disputes, or is it better to litigate software contract disputes? And I think there really is no right or wrong answers. Some of the advantages arbitration has over litigation is that arbitration is typically less expensive than litigation, and it's typically much faster to come to a resolution than litigation. Now, the reason for that is in most arbitration forums, there's usually an abbreviated discovery process. There is typically limited use of traditional discovery devices that are made use of in a court proceeding. And there's also a very limited number of depositions that are allowed in an arbitration proceeding. And in fact, in some arbitration forums, depositions aren't allowed at all. One of the other major advantages I think that arbitration has over litigation is that you are able to pick the arbitrator among a pool of available arbitrators. You're able to review their qualifications and strike through arbitrators that you believe are unacceptable to you. That's something that's simply not available in the litigation context. Some of the disadvantages of arbitration are that while it's less expensive overall, I think that the filing fees associated with filing a demand for arbitration are usually much higher than filing a lawsuit. The parties also are required to share in the compensation of the arbitrator, and arbitrator fees are typically very expensive, and they're on par with attorney rates, attorney hourly rates. One of the other major disadvantages associated with arbitration is that I think that the outcome really is less certain than it would be in a litigation context. And the reason for that is that arbitrators have great flexibility, really more flexibility than a judge would have, to fashion remedies they believe are just. They've got a lot of flexibility in interpreting contracts the way that they want to interpret them. So I think you have a less finite kind of situation than you would if you're going before a judge in a court proceeding. One of the other major disadvantages of litigation is that in the event that you get a bad decision or an erroneous decision that is not favorable to you, you have a very limited availability of an appeal. You're most likely just going to be stuck with whatever particular arbitration decision that you've got, unless it falls within a very narrow scope of appealability. So I think if you're going to take advantage of some of the benefits of arbitration, it's incumbent upon you to include in your software contract a very robust software arbitration provision that really seeks to maximize the benefits of arbitration while at the same time minimizing some of the disadvantages of arbitration. If you have any issues or questions with any of the issues in this video, please feel free to give our office a call at 312-263-0570. Thank you.